Would y'all, I'm gonna print one, if you print the other, please. It's MTRPs. Robert Joseph, if you'll print the somebody print the second one, please. Give me just a second. Get these printed out. Look, I can probably get it before you with your computer. You got it?
Yes, ma'am.
Okay. All right, well, you're Robert Felix Jr., Joseph Jr., and will your client waive the formal reading of the motion in each case?
He will, Your Honor.
In cause number 21-38610, I have a motion to revoke your community supervision. Shows that you were placed on probation May 8th of 2023 for the first-degree felony offense of manufacturing or delivering a controlled substance. And that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes.
In cause number 21-38611, I also have a motion to revoke your community supervision. Shows that you were placed on probation May 8th of 2023 for the third-degree felony offense of unlawful possession of a firearm by a felon, and that was also a 10-year sentence that was probated for 10 years. Is that correct? Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of public intoxication October 3rd of 2025, and is that true or not true?
True.
Count 2 in each case alleges that you failed to maintain your financial obligation to the GPS device company, failed to charge that as well, and is that true or not true?
True.
And then count 3 in each case alleges that you're behind in your court assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 in each case freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true? In both of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand if I go along with this agreement today that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if I go along with this agreement that this is a huge opportunity based on your history and what you're in here for?
Judge, if may I provide the
Sure.
explanation
Yes,
to
ma'am.
the court? I certainly agree with what the court just said. I know this defendant from his being here before. He's not somebody that needs to be in this courtroom. He's 18 hours shy of college degree. He was a college football player. He got totally off track.
Yeah.
And has just, I've spoken with him in the back. I've spoken with his probation officer. She asked that the court consider this sanction and allow him to be released for the holidays with the understanding that the pretty low offer that Mr. Rojas and I had discussed previously is now off the table, that he will be on zero tolerance if the court would allow, that he will have to continue to have that GPS on and show you that he can do what he's supposed to do with it. He was hemming and hawing back there about how much he spent on it, and I told him, in my opinion, he's going to have to prove to you that he can stay on that GPS and do what he's supposed to do and do what Ms. Bradley asked of him, what you asked of him. And if he does that, I'm willing to give him the opportunity, if you are, with the understanding that if he's back, I will ask for the full time.
So, and I recognize you as well, and I know you shouldn't be in here, and it looks like you were doing well for quite some time. And so I'm gonna do what everybody feels like you have the opportunity, your probation officer, the district attorney's office. Because of the nature of the offense and what was going on, at least for some amount of time, you're gonna have to wear the GPS monitoring device. And so I know it's not cheap. You're gonna have to get a job and figure it out. It's very important. It's charged at all times. It's paid for. I've got to know where you are and that you're doing the right things.
Yes.
If you do that for some amount of time correctly, it's always charged. It's paid for. You're up to date. then you can ask your probation officer to ask me if I'll let that go. And I probably will.
So I can answer directly.
They send me, so I have a box in my office that I get a pile of stuff from probation every single day. Early terminations, requests for monitoring device to be, all of those things. But they're not going to send it over and ask me on your behalf if you have not done everything you're supposed to.
They told me I had to hire another lawyer.
Well, they can send it over. Now, if you want to, a lawyer could file a motion. They can send the request over for you. But, and I'll take a look at it and see what all's been going on and talk with your probation officer again about how long you've been on it and what's been going on. If there's any change, I'll let her know. But for now, based on the new allegation, you need to get it, keep it, and then I'll reevaluate that, okay?
Yes.
So this was a plea agreement, obviously, that I followed, and so you've waived any right to appeal. I handed you the trial court certification that shows that, all right? Good luck to you, sir. You can go back with the bailiff. Oh, and so, sorry, I feel like I skipped everything, actually. So the agreement was also for 60-day jail sanction, and that's with credit for time he's been sitting.
Yes, Judge.
And he has you've been in there.
Today is day 64.
Okay, so state tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Joseph is not competent.
No, Your Honor.
All right, then I am going to, again, follow the agreement and continue you on probation. Order that 60 days up front as but with credit for it as a sanction in both of your cases. And so you should be released today, it sounds like. Go straight to probation, get everything back in order, and then you'll be fine. Okay? All right, good luck to you, sir. You need one too?
Thank you. I'm sorry, excuse me.
Good morning, are you John Willis? And we are client with the formal reading of the indictment. Mr. Willis, in cause number 25, DCCR 1048, you're charged with the second-degree felony offense of burglary of a habitation, and that's from June 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Answer out loud, please. And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $300 fine. There would be a dismissal in misdemeanor cause number 25 CCCR 1654, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up.
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Willis is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. Ms. Malfino, what is the state's position with regard to bond?
Judge, I have no objection to a PSI bond in this case. The court will recall that on October 21st of this year, this defendant was before you with respect to a bond. The complainant was also here. Just to be candid with the court, she has been very back and forth, so to speak, about her desire to prosecute or not a misdemeanor versus a felony. I spoke with her again a few times yesterday. This is what she asked me to do, is put him on the felony probation with the court to supervise him. I would ask that in the interim period that we go back to those bond conditions, or PSI bond conditions, whatever we need to call it, that were a no contact with the complainant, a GPS monitor, and the fact that you ordered him to reside with his mom in Iberia Parish at 726 Burglary Street. He's just been unable to post that $7,500 bond that you gave him that day, so he's been in custody this entire time.
Okay, do you understand all of that? And you understand, if I reduce your bond today, that those are all going to be conditions of your bond. I understand that Ms. Richards has gone back and forth, and you guys are going back and forth, but until sentencing and possibly beyond that, you're not to have any contact or communication with her. She can't give you permission. I think I went over all this probably at that hearing. She can't give you permission to violate my order, okay? She can't. So, and you're still planning on going and living with your mom in Iberia Parish, correct? So what I'm going to do, Mr. Willis, is reduce your bond at this time to $1,000. I am going to order pending sentencing if you make that bond. And do you think you'll be able to make the $1,000 bond? Okay. So you're going to be ordered to get a GPS monitoring device. And so the bond is lower. You're not going to have to pay a lot to get out of jail, but you are going to have to pay for and keep a GPS monitoring device on at least until sentencing, just so I know you're doing the right thing between now and then, okay? We'll discuss it again at sentencing. And you're ordered to live in Iberia Parish with your mom and remain in Iberia Parish except coming back to Jefferson County for court, okay?
Can I ask you something?
Uh-huh.
I have a son in Lake Charles. Would I be able to visit?
Yes, you can go to Lake Charles to visit your son.
Okay.
So whatever, do y'all have court orders or do y'all just go visit? Okay. So the main thing is that you're not back here and you're not having contact or communication with Colette Richards, okay? All right, we'll see you back at sentencing. You can go back with the bailiff. I know, I almost wish that we had done it just for,
Because they gave them the wrong name and date of birth to the cops. She told them she was a juvenile. She was only 16.
well, and you know what? Now that you did that, maybe I should have, because it might have been worth it. Her last was 8, so I figured. Okay, what are we doing here? This is an MTRP.
Yes.
All right, are you Latrick Williams? And will your client waive the formal, oh, never mind. I just remembered what we were doing. All right, so it's cause number 24 DCCR 1791. Mr. Williams was on probation, on a deferred probation. Let me just go back so I can put everything correct on the record, for theft of a firearm. Which is, everyone agrees at this point, a state jail felony. And the paperwork for the motion to revoke read a third-degree felony, and we all just went with that. And I revoked Mr. Williams' probation. He was sentenced to TDC, and it has now come to our attention that that was obviously a mistake and that we need to get him sentenced correctly to the state jail felony. So with that being said, I would entertain a motion for a new trial, even though it is outside the time.
We would move for a new trial at this point, Judge, based on the correct sentence.
Any objection to that?
No objection.
All right, then at this time, I will grant a motion for new trial, even though it is outside the time frame to do that. And so what that means is we're back like nothing happened before that. The case is still pending, you're on the probation, but it's like I did not revoke you, so we're kind of starting over at that point where we were just in October, okay? And it's my understanding that you guys have visited and come up with an agreement with regard to punishment for the state jail felony, correct?
Yes, ma'am.
And so I think to make the record clean, let's go back through the motion itself, and I'm going to get pleas of true or not true. It looked like before it was 1 through 3 and then 5 and 6, and so I'll just read those that you pled true to already, okay? And so will he waive the formal reading of that motion again? And so let me, I'm just going to print it. It'll be easier for me to, oh, thanks. So in 24 DCCR 1791, I've got a motion to revoke your unadjudicated probation. Shows that you were placed on Would the state like to make a oral motion to amend the motion to adjudicate?
Yes, Judge.
Okay.
No objection.
To read?
To read that it is a state jail felony.
Okay. No objection to that. Okay. So, again, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 24th, 2024 for the state jail felony offense of theft of a firearm. And that was a 5-year deferred probation. Is that correct? And it alleges in count 1 that you violated your probation by committing the offense of unlawful carrying a weapon May 12th of 2025 in Jefferson County, Texas. Is that true or not true? Count 2 alleges that you committed the offense of unlawful carrying a weapon May 25th of 2025 in Jefferson County. Is that true or not true? Count 3 alleges that you committed the offense of minor in possession of alcohol May 25th of 2025. Is that true or not true? Count 5 alleges that you committed the offense of resisting arrest or transport May 27th of 2025. And is that true or not true? And then count 6 alleges that you failed to report as directed February 10th and May 15th of 2025. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, 5, and 6 freely and voluntarily? And because those counts are actually true. I have some documents on the tablet like we had before that you've done today with Ms. Holmes. Did you go over those with her before you signed them? You fully understand them. And you understand if I follow this agreement, you'll be waiving any right to appeal. State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 3, 5, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of a firearm. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you another copy of that admonishment regarding your ineligibility to possess a firearm or ammunition. I already read that to you last month. I'm not going to read it again. You understand you cannot possess a firearm because of this conviction in Texas, right? Okay, you can go back with the bailiff. Thank y'all.